Okay, what if there is a breach of the contract? The person on the other side either refuses to perform or cannot perform. They will not perform the duties of the contract, and you have to sue them for breach of the contract. What are the legal remedies, the damages, if you will, that you can recover? There are a number of different remedies. You can recover compensatory damages to compensate you for the actual loss that was caused. A guy breaches his contract to deliver the 10,000 bicycle frames to you, so you lose your sale to Walmart and you would have made profit of $40 a bike on each of those 10,000 bikes. So a $40,000 loss, and you can be compensated for that. There are also, you can recover consequential damages. So these are damages that are a direct consequence of the breach of contract. Walmart told you that if they liked the first 10,000 bicycles, they were going to buy another 10,000 the following month, but because you were not able to deliver on time, you lose the second order. You might be able to sue and recover for the loss of the second order, another $40,000 of lost profits as consequential damages. So you can recover compensatory damages for direct loss caused, consequential damages for an indirect loss caused, and nominal damages is kind of a weird little thing in the law. Nominal damages are kind of an odd thing that happens. It's fairly rare, but it can happen, and that is where both parties to the contract have not behaved very well, and they get to court and they're nasty and they're fighting, and the judge or the jury says, you know, we don't really like either one of you very much. We don't think either one of you acted very fairly, but we're here in court and we have to pick a winner, so we pick this guy to be the winner, but we award him $1 as nominal damages, and we say, both you guys get out of here, we don't like either one of you. So that's nominal damages. So you can recover compensatory damages, consequential damages, and you might recover nominal damages. But an important thing for you to learn is there's one kind of damages that you cannot recover in a normal breach of contract case, and that is punitive damages. We do not spend time in court fighting over whether or not someone should be punished because they breached a contract. Contracts get broken all the time, and sometimes it's by bad behavior or intentional breach of the contract, but most of the time it's changes in the world, the business world, and beyond someone's control. And so the basic law is no punitive damages in breach of contract cases. We don't punish people for breaching a contract. We have also one other remedy that you may be able to get in a contract case if money damages is not sufficient to make you whole. And the example that I give on this is, perhaps you have in your mind a dream house. Most people, if you ask them, they can give you details. They can see it in their mind, how they want this dream house to look. It may have acreage out in the country, or it may have a white picket fence. One guy said his had a big car garage right next to his bedroom, so he could keep his exotic cars right next to his bed. So everyone has a different taste, but if you were driving down the road and all of a sudden you put on the brake because you looked over there and you saw, wow, someone must have ESP because they built my dream home. That's exactly like I always envisioned it. That's the house I want, and look at that, it's for sale. And so you call up about it and you find out, wow, it's a bit of a stretch, but I could actually afford to put in a bid on it. You put in a bid on your dream house and they accept your bid, and you're in escrow waiting for the deal to close, and then the real estate broker calls you up and says, I'm sorry, but the sellers have backed out of the deal. They got a bigger offer, and so they're breaching your contract with you. Well, you know, if you can sue them for money damages for the loss of the deal on the house, and maybe money damages would be good enough, but there are some things in the world that are unique in all the world, and that one house on that one piece of land at that very location, that's unique. You'll never find another house exactly like that one. And when you contract to purchase something that is unique in all the world, it may just be that money damages are not an adequate remedy. They don't really make you whole or make you well. And so in those kinds of cases, you can sue for a different remedy, which is called specific performance. And when you sue for specific performance, you say, Judge, I want that house. That's my dream house. There's no other house like that in all the world. They entered into a contract with me to sell me that house for $500,000. Here I stand with my check in hand. I'm ready to pay them the $500,000. I don't want money damages. I want a court order that they specifically perform the contract and they sell me that house. You can sue for specific performance, and sometimes you can win that. Now, we need to look for a minute. I want you to imagine that you are a rich landlord. You own the Galleria shopping mall, and one of the shopkeepers in the mall rents retail store space from you at $10,000 a month. And they do okay they have a 5-year lease. They're going to be in there paying you $10,000 a month for the next 5 years. And they're in there for a year or two and everything's okay. But then the pandemic occurs and they go broke. And they call you up and they say, we're sorry, we're not going to be able to pay you the last 3 years of the lease. We're closing our doors. Well, if you have a 5-year lease with them, you could sue them for the remaining 3 years at $10,000 a month. That's a lot of money. And that's the contract. If they shut their doors and they can't pay you for the balance of the 5-year lease, you can sue them for the last 3 years of the lease. But the law imposes upon you a duty to do what's called mitigation of damages, to mitigate the damages. Mitigate means minimize. So you cannot just sit there and let that store space lay open and unrented for the next 3 years and sue for the whole 3-year balance of the lease. You have to do everything, use your best efforts to clean up that space and advertise it and market it and get it rented to somebody else. And then you have reduced or mitigated your damages, because maybe you rent it to the next guy for $10,000 a month, and your damages now are not 3 years of unpaid rent at $10,000 a month. Your damages are only the 2 or 3 months that the store sat empty until you rented it to somebody else. Of course, if the economy crumps and you can only rent it to the next guy for $5,000 a month, then your mitigation is $5,000 a month, but the other guy still owes you for 3 more years at the difference between the $10,000 rent and the $5,000 rent. But the point here is that whenever there's a breach of contract, if you're the party that's been hurt by the breach, you can't just sit there with all of your damage and sue for the whole amount of damages. You must do whatever you can do to mitigate or minimize the damages that you suffer. Then when you go to court, you have a legitimate claim. Another odd thing that happens with contracts from time to time, not really odd, but you may not have seen it before, is what is called liquidated damages. Sometimes you enter into a contract for something, say you're an event planner, and you enter into a contract with a big rock and roll band. You're going to put on a big charity event, and the rock and roll band is going to be the big draw, but you're going to sell really high-priced tickets, and all the profit's going to go to charity. And then the rock and roll band doesn't show up. Well, you got a lot of unhappy people out there, and they may pull their donations to the charity, and they may want their money back for their tickets, but some of them may say, oh, you can keep the money, it's for charity. You got a mess on your hands, and it's difficult or impossible for you to estimate just how much the damages will be if the band doesn't show up. And when it's difficult to estimate how much the damages will be, and you don't want to fight over that later in court, you can agree ahead of time. You can say, we agree that a reasonable estimate of what the damages will be is $100,000 if you don't show up and perform on the night scheduled for the performance. And then if they don't show up, they have to pay you the $100,000 in damages. You don't have to fight in court over what the amount of the damages will be because you've already determined that by prior agreement. Now, if you're the event planner and you're thinking about getting a liquidated damages clause in your contract with the rock and roll band, you may say, well, I want to make sure these guys show up, even if they have to crawl out of their deathbeds and croak one song, because they're going to ruin my event if they don't. So let's make the liquidated damages $10 million, and then they'll crawl out of their deathbed if they have to get there to sing. Well, liquidated damages have to be a reasonable estimate of what the actual damages would be. The liquidated damages cannot be such a large amount that it looks like it is punitive in nature. If you make the estimated amount of the liquidated damages too high, then the court will not enforce that. So liquidated damages have to be for a reasonable amount. You can rescind a contract if there's been fraud, mistake, or duress, or undue influence, or lack of capacity to contract. You may be able to rescind the contract, and that may be a contract type of remedy. If there's some kind of typographical error in the contract, somebody misplaced a decimal point, and part of the job was supposed to be $50,000, but the decimal point got misplaced and it's only $5,000. If you can't agree with the other side about fixing that, you can go to court and ask the court to do what's called a reformation of the contract. And if it's just an honest mistake and the judge wants to make it fair, the judge may order reformation of the contract and say, move that decimal point over and make it back to 50,000 instead of 5,000. Remember also that if the contract itself turns out to be invalid and unenforceable for something like the failure to get the writing, you still may be able to recover on an equitable theory like quantum meruit, unjust enrichment, promissory estoppel, or quasi-contract is one we haven't described before, but it's when people act as if there is a contract and later try to get out of it. If when you sue for breach of the contract, you have more than one potential remedy, like you have made a loan that's secured by a mortgage, and you have two different remedies, you may be able to sue to foreclose on the mortgage, or alternatively, the house doesn't have that much value, and so you sue for the total amount of the money owed instead. You can't sue for both things. At some point, you must do what's called an election of remedies, and you must pick one of the two different possible remedies you have and tell the court which one you want to take. And sometimes that's a difficult, strategic decision in times like the real estate market crash of 2008. There is a problem with sitting on your rights for too long. If you have a contract with someone and they're supposed to pay you $500 a month and they miss a couple of months, well, you make demand, and if they don't pay, then you sue them. But what if they don't pay for 6 months or a year, and then you decide you've had it with them and you want to make demand for payment and sue them? Well, you may have waived your right to sue them if you sat on your rights for 6 months or a year, because at some point a waiver argument comes in as a defense to their having to pay. They say, look, Judge, if I had missed 1 or 2 payments and he had sued me, I would have understood that. But a year went by and I didn't make a single payment during that whole year, and he never said anything about it, and so now I was lulled into a false sense of security that he was never going to come after me for that money, and so I made other plans with my life. I budgeted other expenses, I got into other contracts, and now he shows up and sues me. No fair. Well, that's a waiver argument. That's one of the reasons why bankers that loan you money, whether they want to or not, there's a limit on how many months they can wait before they sue you, because if they wait too long, there's a danger of waiver. So if you're owed money and people miss a couple of payments, you got to get right on them, or you may run into a waiver problem.